Hey everybody, good morning. It's Mike Shea again. This time I've got Kenn Gluckman of Moran. I've known Kenn for 15, 16 years.
Yeah, at least.
And Kenn has been doing business transactions and working with buyers and sellers in Orlando for a lot longer than 16 years, probably closer to 25, 30. Yes, he's that old.
25.
Yeah, 25. So what I wanted to do real quick is, a continuation of this kind of series is to get local experts who can give some real top line advice in a short period of time about what people should do when they're buying a business, selling a business. So Kenn, why don't you give a quick history on yourself, Moran Kid, what they do, and then we'll go right into some buyer fundamentals when buying a business.
Great. So my name is Kenn Gluckman, and I'm an attorney, Lyons Johnson Garcia in Orlando, Florida. And we work with a number of businesses on different issues, transactional estate, corporate matters, and litigation, as well as workers' compensation for employers. We have been in business for quite a while. I'm in my 25th year of practice and work with a wide range of different types of business and business owners.
Okay. So from a buyer's perspective, what are the fundamentals buyers got to do before they, as they go through the buying process? From a legal perspective.
Well, from a legal perspective, I think that the buyer needs to make sure they have a good handle on the business they're buying. They understand how the business should be run, so they can compare when they review the business fundamentals. From a legal standpoint, it's important to look at contract issues and understanding that type of business, what kind they have. Should it be writing? Should it be, or is it more casual? Is it a larger company? And the larger the company, the more sophisticated contracts you'd expect to see. You'd also look at issues with employees are important from a legal standpoint. How many employees do they have? What does that mean from impact of employment laws on the business? And have they kept up with it? Good HR process and good documentation. They got claims outstanding is a very important issue to discover early on. And are those legal claims things that need to be dealt with before the closing? Are they going to be ongoing? If they go past the closing, what does that mean for the business? And what's the buyer going to have to deal with? What kind of insurance is involved? And who's handling those claims? So some of the basic things I would worry about initially for the buyer.
By the way, that's not everything, right? That's the list can
Right.
go on and is case specific. Those are legal disclaimer for the purpose of this conversation. So
Absolutely.
But they need to incorporate, right? And then you guys can figure out what that, there's different types of corporations and that are really, needed for different types of situations, both with regard to the business and regard to the buyer in particular on a personal level, right?
Right. So we would look at, initial consideration, maybe is it an asset purchase versus a stock or membership interest purchase, in which case a person may not, or a limited liability company for their transaction. But most of the deals, many of them are looking at, especially smaller deals, are looking at asset purchases. That's the better way to go. The situation of this. And in that instance, you've got to look at the company, have it ready and in place to be able to make the purchase at the time so that you've limited your potential liabilities.
So you kind of tipped on a point is the majority of the time in the transactions that you and I are doing, and Kenn and I have probably done, well over 170 some odd transactions together over the years. The majority of the time we're dealing with asset sales. So, a $300,000 purchase, a Main Street deal, someone's buying a job, a pizza parlor, they're generally, straight asset sales with very few exceptions do we see otherwise, right?
That's
you might want
right.
to
Generally on the small.
Explain the difference between an asset sale and then, because that's often something people get confused with when they're buying companies.
Sure. So the thing to understand is that that's been created and has the asset protection in place. So a company is generally a bucket, and that bucket holds assets. And so the question is, are you selling the bucket, which holds all the asset, which we look at as an ownership sale, or are you just scooping out the assets, leaving the liabilities within the bucket, and just buying the assets and whatever liabilities that you actually want to take with the business? So that's the main difference.
Yeah, and the majority of the time, we're not doing, stock sales and buying the company. I think I can count on one hand how many times I've done stock sales in 16 years, right?
Right. So again, I do a number of stock sales with my practice, but that generally is going to be larger scale businesses or very specific, maybe a doctor practice, something that has a license issue. Most of the deals we're looking at are asset purchases or sales, and those are really the best for the buyer in the sense that you're only buying what you are expecting to buy, and you have a lot fewer potential liabilities that could sneak up on you.
So in the majority of the stuff when I'm interfacing with you, maybe we should talk a little bit about how a transaction attorney works, what you do as part of our closings, and then how brokers and transaction attorneys should work to make the deal kind of smooth.
Okay. So from my perspective, we're often brought in sometimes before the contract is signed, which as the attorney, I always want to come in as early as possible. I think I can provide the most help, but it's really up to the parties what makes sense for them and what they're doing and the size of the deal. Sometimes I work as a closing attorney and just help put the whole transaction together, not technically representing either buyer or seller. In those instances, we are provided a contract, and this is often how you and I work together, where you've put the contract together as the broker, the parties have signed it, and it comes to me, and I'm looking at it from the perspective of, these folks have an agreement on what they want to do, and I need to prepare the documents to allow them to have a closing that is smooth, and it provides for covering what they've agreed to in their contract, what the seller is going to do and how the assets are going to be provided, and what the buyer is going to do in providing the consideration that they're going to either pay a cash deal or have a promissory note, or we're going to have the security in place if there's seller financing. And so we help with all of those issues. And we also help with lender funding. So if there's a lender involved, we can help to make sure that that's a smooth process. And we bring it all together at the closing to try and make sure that the parties get what they're expecting to get, and that post-closing, everything's as smooth as possible.
So to clarify, broker isn't putting together. There's a couple standard contracts that are pretty common in Florida in general and in Central Florida. So there's the Transworld document that some lawyers have put together, and then there's the Business Brokers of Florida standard contract that's been put together. And then those have clauses that a bunch of local attorneys have kind of plugged together to make the standard simple, clean. No deal is simple, but this is as cookie cutter as it gets. And then, if buyers and sellers have a counsel, they can add addendums to it. And that kind of keeps legal fees down with regard to, the initial purchase contract that eventually gets to the transaction attorney, right?
Right. So, yeah, I don't mean to say necessarily the brokers are not acting as lawyers,
Right.
but, as a closing attorney, I often get the contract already signed by the parties, meaning that the parties have agreed to their basic terms, and the brokers facilitated that through providing the standard contract.
So what are the things that are important for a buyer to understand to make a closing go smoothly? Like where do deals go awry in your world, or in my world too, but in your world as well?
Yeah. And it's really important first for, I think, the seller to understand that the more organized they can be, the more they have good books, good records, tax returns on hand, things that are available for the buyer to look at and understand the business, the better off they're going to be. And so from the buyer's perspective, you want to come in, and depending on the specific business, you might want to look at things pertaining to that business. I always find it fascinating that if you're buying a dry cleaner business, you need to look at their water bill, because how much water they use has a huge impact on whether their books are accurate in tracking their revenue. And you can look at water usage as a way of looking at that. And so every business is distinct, but different categories of businesses have specific things that I think the buyer needs to understand. And that's someplace that you as the broker, I know, help them a lot with your experience in looking at those things. And so from a legal perspective, we want the buyer to come in with an understanding of the business again, but also, be able to evaluate the business based on what they're seeing and comparing it to other businesses.
So having good advisors, intelligent advisors, particularly CPAs who have experience in the business that they're looking at. Like, one of the common issues we see is they hire, there's always an element of trust and fear, right? And there's a dichotomy there. So they may hire their local accountant or the person who's done their personal taxes for 20 years, but that person's never looked at a dry cleaner or had clients who were in dry cleaners. So he or she has no point of reference with regard to like water bills like that. I'm always laughing when people look at, they want to see a balance sheet, and I'm like, water bill's not showing up on the balance sheet. There are certain, and every business has those things. And unless you deal in small business every day, you don't know. So it's important that you solicit people who have experience doing these types of things, so that when you get to the closing, there's no surprises. So, I can get a due diligence list from somebody if I'm representing a seller, and I'll do a double take and go, and you're asking the wrong questions. But it's kind of like, how do you ask somebody how often do they beat their wife? It's a double-edged sword, and you're not trying to put off that their questions unimportant, but relative to what really matters, because we have experience and they don't. How do you kind of subtly say, look, I respect you, but you're not asking the right questions, right? Or your understanding of done transactions. Not all transactions are the same. Not all industries are the same. Time in the desert matters, right?
Absolutely. And if you don't have an advisor advising you to talk to, to ask about, say, gift cards, if you're buying a restaurant or a salon or something like that, gift cards are a huge issue. And I'm always amazed at how often people don't think to ask about it. And then it comes up after closing, if we haven't brought it up ahead of time, and becomes a huge issue. And so that's another example. Absolutely.
And in property management, which we do a lot about, how are we handling the future bookings, all those things that if you don't know to ask, sometimes people are honest through omission. If I'm not asked, I'm not going to tell you, right? All right. And
absolutely.
The buyers and sellers both need to understand the brokers and what their scope of work is. So, I'm pretty scared of stepping outside the scope of practice, but I think you've probably seen on occasion where, you and I have been in closings where an opposing broker was actually negotiating with an attorney, acting like counsel, and my head was spinning, going, wow, the buyer's being misrepresented, and B, someone's being outgunned here and is practicing law, and they have to be really careful about doing that, right?
No, absolutely. And I think it's important, both with the broker, with the CPA involved, with the attorney involved, that everybody has a good comfort level with that size business transaction, with that type of business, with the things that we need to look at behind the scenes to understand and be prepared for. There are different ways. For example, you talked about the property management business. There are different ways of putting down money coming in as revenue. Is a deposit revenue, or is it something else? Should it be held as a liability? And some, we've some deals we've done together, we've seen people categorize it differently, and where sellers have taken money in a deposit, and they said, well, we're going to end up keeping this no matter what because we have a cancellation fee, so we're going to record that as revenue initially. And then when the buyer takes over the business, they think they're going to get the whole deposit, and it turns out that they're short 10 or 20% that the buyer has kept, claiming, well, that wasn't a deposit, that was actually a prepayment of money we were going to get no matter what. So lots of different issues to consider.
Yeah, and so you have to make sure that everybody in the transaction has done those types of transactions so that those things don't occur. Ideally, a closing should take 20, 30 minutes, right? We're done.
On a cash deal, we should be in and out pretty quick. If everybody has taken the time to review the documents and we've got good documents prepared, we've talked through the main issues, everybody's on the same page, it should be very, very quick and easy.
So the other stuff I want to kind of wrap up with is you do a lot of SBA deals with who it should get interesting in the next 3, 4 months, 6 months with regard to SBA. But sometimes, and this is if you're doing a bigger deal and you're a buyer and you're getting SBA financing, you need to make sure that the attorneys involved have done them before and they have relationships with the banks because it's different. All I can say is, getting everything ready for an SBA banker and the BDO and the lien searches and having it all coordinated is not for the faint of heart. And your counsel needs to have a team to collect the data because it's a massive amount of paperwork. And there's like a whole closing before a closing that goes on, right?
Absolutely. And when we're dealing with lenders, as you mentioned, we deal with a lot of SBA deals. And it really varies depending on whether it's a small bank, a large bank, a bank from a different state. I'm always intrigued to see what they're going to come up with that they require of the buyer as the borrower to provide, whether it's guarantees or whether it's certain information, collateral. And almost in every instance, the lender is saying, well, this is the SBA requirement. And one of the things we help to push back on is to say, well, we've done many of these deals and nobody else required it. So how is this an SBA requirement?
Right.
Do you really need this? And that's something that can be very helpful.
Right. Because, some of your fees tied to the bank are unnecessary documents driven by an independent bank, in Utah who's coming up with something that is not normal. And unless you've actually been down that path, you don't know that when they're asking for your grandmother's title to her home, that it's nonsense. You're assuming it's true because who would ever lie to you? Right.
Don't lie. Yeah, and they're certainly not lying, specifically. They just
who would ever just blindly follow the path of whoever just threw it down. Some lawyer in a bank somewhere out of state is making up something because that's the way they did it in Utah. Right.
Absolutely. Right. Yeah, and there certainly are legitimate things that you would have to provide if you were in Utah that you don't need to provide in Florida because our systems are different.
Right. So every state has different rules. Some are licensed states, some are not licensed states, and there's all sorts of protocols, and you have to have experience with it. Or, when going back to our topic is like you need a lawyer who's been in the desert or done these deals before, and there's different rules for different states. Not a lawyer in New York is not a lawyer in Florida, right?
Absolutely.
Unless you pass the bar, you can't practice law, right? So, that's kind of the rules of the game. So, real quick, how can people get a hold of you?
You can reach me at 407-841-4141. Glad to help folks however I can. There are certainly occasions where we talk through general items before everybody gets engaged, and I'm glad to help.
Okay. And he's at Moran Kid, downtown Orlando. And I can tell you that one of the great things about Kenn is if you need to get a hold of him, he answers his phone. And if I need to get a hold of him, he answers his phone on Saturdays and Sundays. Not for everybody, but for me at least, he does. And one of the best things about Kenn and his team is that they know when to fight, but they're not going to fight in a manner that just makes people upset, that doesn't get him anywhere. And what I mean by that is he's not fighting or arguing for the sake of arguing. He's trying to get the best outcome at every time. And that doesn't always mean banging your head against the wall or screaming and yelling. That's certainly appropriate at certain times, but normatively, when there's I always like Kenn in a transaction because he's level-headed and calm, and he gets it done to the best outcome of his client. Not always my best outcome, but always the best outcome of his client. So ethically, is a way above par. Thanks.
I appreciate that. I like to say that, I'm a lawyer who is recognizing that it's not my deal. And that's something that drives me crazy with other attorneys. And when they say, I won't let my client close this deal because of X, Y, and Z. And my response is always, it's not up to you. It's up to your client. You need to explain what the risks are, work with them to make sure they understand the deal. And as much of, what could go bad as can be identified. But it isn't our job as lawyers to tell you what you can and can't do. It's our job to
nor is it the job of the brokers to do the same.
Right. We'll share the risks, and you have to make the decision as the buyer or the seller of what you want to do and what makes sense for you.
Right, because there's no perfect deal.
Right.
There's fear on every deal, and you're never going to, particularly in business deals, particularly in heavy goodwill business deals, there's no winning and beating the other guy, because sometimes a seller being passive aggressive and saying nothing can be the worst thing in the world. So the deal has to work for both parties. There's always going to be a little bit of risk. You can't eliminate it all. It's not a house, right? It's not a brick and mortar asset that goes up and down with the market. There's usually a heavy amount of goodwill, and the buyer and the sellers need to make decisions based upon counsel's advice, and the attorney's advice and their broker's advice and their other outside advisors' advice, but they're in charge. We're not in charge.
Right.
Right.
Yeah, and it's important, that everybody is working together, and the more that we can work together as advisors and see and help the buyer and the seller to work together, if they can work together on putting a deal together and getting it to the closing table, then the transition of the business is going to work so much better, and we see that again and again.
Yeah, if they're fighting before the closing, it's not going to end well.
And not a good sign.
No, it usually ends up blowing up, and you and I don't want those phone calls.
Right.
Yeah,
absolutely.
Nobody wins. All right. Thanks. Stay safe.
All right. Thank you. You stay safe as well.
Yep.
Talk to you soon.